Hello students, welcome to BYJU'S IAS. In today's live session, let's have a detailed discussion related to one of the very important current affairs topic, that is the draft rules for e-commerce companies, which has been published very recently by the government. Now, a couple of days ago, the government came out with these particular draft guidelines or draft rules, and once these particular draft rules were announced, there has been a lot of discussion as to what is the impact of these particular rules, not only on the sellers, on the e-commerce entities, and even on the customers or the consumers, that is me and you. So in today's live session, let's try and understand what is the fuss all about. But before I start the discussion, please make a note of the point that these are just the draft rules. These are not the rules or the regulations which have been notified by the government. These are just the draft rules. In simple terms, these are just the proposals which have been put forward by the government of India. Now, before these particular proposals are actually implemented, they have basically asked the feedback from all the stakeholders. Once the feedback is provided, they will take into consideration this particular feedback and then notify these particular rules. So, you will have to make a note of this particular point. Now, let's start the discussion. Now, before understanding what are the draft rules, let's try and understand certain basic concepts first. Starting with, what do you mean by the term e-commerce? Now, various points of time, whether you are reading a book or a magazine or a newspaper, they will often refer to this particular term e-commerce company or e-commerce industry. But what do you mean by the term e-commerce? E-commerce simply refers to a process wherein commercial transactions such as buying and selling are taking place online. Is it okay? Whenever through digital means, whether you purchase or sell the goods, this particular process is called as e-commerce. Now, over a period of time, not only just in India, but around the world also, that is in developed countries as well as developing countries, this particular concept of e-commerce has evolved. It has grown at an exponential pace and has become very pertinent or very much important for the governments to regulate this particular industry. And as of now, we do not have a common rule across all the countries. But one point that you must remember is with respect to the regulation of e-commerce, United Nations General Assembly, UNGS stands for United Nations General Assembly, set up United Nations Commission on International Trade and Law. Is it okay? UNCTRAL, UNCITRAL, United Nations Commission on International Trade and Law. This particular authority was set up by United Nations General Assembly in 1996, and this particular authority has come out with certain model law with respect to e-commerce, that is a model e-commerce law. And this particular model e-commerce law was adopted in the year 1996 itself. And this particular model law basically allows various member countries to have their own law to regulate e-commerce. And based on these kinds of model laws itself, Government of India has introduced IT Act, Information Technology Act. You must have heard of this. This was there in the recent discussion. And based on this only, Government of India has come out with Consumer Protection Act, that is specifically with respect to e-commerce. Now understand this, with respect to Consumer Protection Act, which is considered to be the Magna Carta in case of Indian economy or Indian law, which protects the consumers, which protects the buyers in the market. Initially, it was introduced in 1986 and very recently it has been amended. So, right now this particular Consumer Protection Act which is applicable, right now which is applicable is the law of 2019. And under this particular Consumer Protection Act itself, there are two very important sections. Please remember these particular sections. One is section 94 and section 101 or 101. Section 94 basically allows the various government at the central level, or it allows the central government to come out with law or to come out with rules to protect the customers. especially in the e-commerce sector. And based on this particular provision or the section 94, there is one more section 101, the government has notified these particular rules or the provisions to protect the interest of the customers under the e-commerce segment. So let's go ahead. After this, Government of India in the year 2020, from July 2020, came out with these particular e-commerce guidelines. The technical term that you will be coming across in the newspapers is the Consumer Protection or Customer Protection e-commerce rules. Is it okay? This is a technical term. And what has the Government of India done? After notification of these particular rules or guidelines, again it has kept on receiving various complaints against the e-commerce companies. And now to plug certain loopholes in this particular rules, now the Government of India has proposed an amendment. Is it okay? It has proposed to amend this particular the law or the list of rules which it had earlier proposed in the year 2020. So let's try and understand what are these particular draft guidelines or draft rules which has been proposed by the government. But before that, in case of India, the e-commerce sector has ballooned in terms of market value. As per latest report, in case of India, the e-commerce sector accounts to around $80 billion worth of market value, around $80 billion. And as per various estimations, this particular value is going to increase in the coming days. And as per various surveys, it has been shown that by 2024, the total number of the buyers through e-commerce is going to be more than 200 million. And because of the penetration of internet connection in case of Indian market, both in case of urban India as well as rural India, the number of buyers or the number of consumers through e-commerce is only going to increase. Now, in order to regulate this, the government has brought in the guidelines or the rules. But before that, what are certain complaints against this particular concept of e-commerce or e-tailers in case of India? And many of these particular complaints have been addressed through the draft guidelines. So let's try and understand the issues first, then the rules. First and foremost, there's a concept of a drip pricing. What do you mean by drip pricing? Imagine you will log on to one of these particular apps or the portal. You will look at a particular product. It basically, the headline price says 1000 rupees. You want to buy the product. So you will add the product to the cart. And without looking any further, you will simply place the order. And you will select your address. And once you come to the payment stage, you will realize that this particular 1000 rupees was just the headline price. In addition to 1000, now the company has added other charges. It has added some of the taxes. And when you are about to place the order finally and make a payment, you realize you are paying much more than 1000 rupees. So this particular process of adding the charges above the headline prices like this particular process is called as drip pricing. And various experts have said that through the process of drip pricing, basically the customers are cheated. In essence, when I say cheated, I am simply saying the true pricing is not revealed by the e-commerce company in the initial phase. When you like the product and you are about to place the order, then in addition to the headline prices, they keep on adding other prices. This particular methodology is called as drip pricing. And there have been various complaints raised with respect to the drip pricing itself. Next issue, preferential treatment. Remember this particular term. Why? Generally in the newspapers, when you are reading, they will use the term preferential treatment. But technically, in the parlance in the industry, they generally use the term winning the buy box. And in the UPSC prelims, if they use this particular term, do not get confused. Winning the buy box essentially means out of all the sellers which are present on the marketplace, there are few sellers which are getting the preferential treatment. Now you will simply ask me, sir, what do you mean by a marketplace? Now please understand, in case of e-commerce segment in India, two types of models are there. One is called as an inventory based model and the second one is called as marketplace model. Let me start with the first one, inventory based model. What do you mean by inventory based model? Imagine you have set up a particular website and you want to sell the products on this particular portal, either website, portal or an app. Don't worry about it. But the goods or the services that you are going to sell through this particular website are the ones which are purchased by you. Is it okay? You own the inventory, you own the goods, and you are selling these particular goods through this particular portal. That is called as inventory based model. And the second type of a model, marketplace model. Best example for a marketplace model, although completely not true, are Amazon, Snapdeal, Flipkart, etc. What happens in a marketplace model? These particular entities will basically set up a market through which they are going to connect the buyer as well as the seller. Is it okay? Amazon will set up this particular website. In this website, it will allow the sellers to be registered. It will allow the consumers to purchase from the sellers. This is the basic idea of a marketplace model. And in case of inventory based model, examples are Jabong, Zivame, Yepme, so on and so forth. Even Big Basket is an example of inventory based model. Now going ahead with respect to these two models, in case of the marketplace model, which is a very famous model, Government of India allows FDI. Up to 100% FDI is allowed through automatic route, and that is the precise reason the marketplace model is thriving in case of Indian economy. It is a marketplace model which occupies majority of the e-commerce market in India. Now have a look at this. Let's come back to the preferential treatment. Imagine I am one of the persons who has set up this particular marketplace. Now in this particular marketplace, all of you, let's say 5,000 people who are watching the video are registered sellers. Out of these particular 5,000, let's say I will give a preferential treatment to 50 of you. I'll simply provide a better access to 50 of you. For example, one customer wants to purchase a particular product, he will search for the product. So in the beginning page itself, those particular sellers, out of these particular 50 group of sellers, those who are selling this particular product, they will be given the first access, or they will be given more access in terms of the search. As a result of this, what will happen? The consumer, when he sees these particular listed products or those particular sellers who have been given a preferential treatment, generally he will opt to purchase, or he will end up purchasing the goods from these particular sellers only. This is called as a preferential treatment. Now in addition to this, there is also a concept of where these particular entities themselves, that is the e-commerce companies, will try to provide an identification badge to these particular sellers. For example, you must have seen the notification, or let's say indication of Amazon fulfilled, Flipkart assured, etc. So generally what they try to do is they try to push these particular products when the consumer or the customer is searching for these particular products. Now some of you will raise a question, sir, what is the problem if the company is pushing these particular products or giving a preferential treatment? What is the problem then? The problem is, I said out of 5,000, I'm preferring, or I'm giving more access, or I'm giving more exposure to 50 of you. Will the remaining 4,000 plus or 4,950 sellers, do you think they will be happy with this? Obviously no. So they will raise an issue. They will start complaining. They will simply say that we are 5,000 sellers, but you are preferring only 50 sellers. That is the concern here. And various sellers have raised complaints against this particular practice of Amazon as well as the Flipkart. Now let me elaborate on this. Have a look at this. Very recently there is a discussion on antitrust case. Remember this, antitrust case against these two particular companies or e-tailers. The Amazon as well as Flipkart, they have been dragged to court. Competition Commission of India is investigating against these two companies. This particular complaint, which we will discuss in later slides, has been raised or has been filed by one of the groups of traders in Delhi. And as a result of this, the basic the complaint of these particular traders is that these two companies are providing a preferential treatment. In addition to this, the Competition Commission of India very recently has cited an investigation which has been conducted by Reuters. As per this particular investigation which has been done by Reuters, it has been seen that this particular company, Amazon, actually gives a preferential treatment to some of these particular sellers. Now, what is the advantage for giving a preferential treatment? The advantage for this particular company, Amazon, is it is one of the stakeholders in top 2 of these particular companies. In essence, what I am trying to say is, if I am owning the marketplace, I said I will give a preferential treatment to 50 sellers. What if I have ownership, some amount of ownership out of these particular 50 companies? What if I have ownership in 10 of them? Obviously, when these particular 10 companies sell more, it is a benefit for me because I am part owner of this particular company. So that has been one complaint against this particular practice of preferential treatment, and the technical term is winning the buy box. Remember this particular term. Let me go to the next one, data privacy and safety. Whenever you are ordering a particular product, have a look at this. Whenever you are ordering a particular product, suddenly the website will give recommendation to you. It will basically say, the people who have purchased this particular product also purchase this particular product. Or if you are purchasing a mobile phone, it will give a recommendation of, let's say, a charger, let's say a protection case, etc. So there is a basic idea of how safe is your data. For example, you want to order a particular product from one of the apps or one of the websites. You will provide the details of your card, you will provide your CVV number. So don't you think your data should be very, very safe? There have been various concerns which have been raised with respect to the data privacy as well as the safety of the customer data. And there is also practice within these particular e-commerce companies which is referred to as cross-selling. There are 2 terms, please do not get confused here. One is cross-selling and the second one is mis-selling. Very recently, Government of India, or to be more precise, the Ministry of Consumer Protection, has brought in a rule against the mis-selling, which we will discuss later. But there is this particular practice of cross-selling. What do you mean by cross-selling? Imagine you are purchasing a mobile phone. Okay, you are purchasing a mobile phone. Suddenly, related products such as, let's say, a wireless charger or a protective case or any other related products related to mobile phone such as memory card, the e-commerce entity through which you are purchasing the mobile phone, they will push these particular products to the consumer. This particular process of selling the related products is called as cross-selling. And how do you think these particular e-commerce companies know you need these kinds of products? Because what type of product you have purchased, what type of a card you have used, what is your email ID, what is your phone number, what is your address, all of this particular data is available to these particular companies. And many of the times you must have read about leakage of the personal data or selling of the personal data. All of this is a very sensitive issue with respect to the e-commerce companies, and there have been complaints again and again raised against these particular companies in regards to this. Next issue, flash sales. I am pretty sure you have heard of this particular term in the last couple of days. And most of the discussion that has been happening with respect to the draft rules proposed by the government are surrounding the concept of a flash sale itself. First and foremost, what do you mean by a flash sale? Understand this term very carefully. As per the government notification itself, flash sale will basically mean some of the important terms or some of the important features. One, huge discount will be provided. First one is what? During flash sale, huge discount is provided. And second, when huge discount is provided, natural outcome will be the prices are very, very low. Is it okay? Discount, prices come down. Third, specific type of products are sold. Specific type of products are sold or limited number of products are sold during flash sale. It is not applicable to every product. E-commerce companies pitch in or basically market only few of these particular products during flash sale. And after this, basically one is discount, price will come down, specific type of products are being sold, and it is for a limited time period. These are some of the terminologies which have been used by the Government of India in order to define what is a flash sale. Now, you must have experienced or you must have got the benefit of this particular flash sale. I am pretty sure all of you have used this, even I have used this. So there is a concern with respect to flash sale or a complaint related to flash sale. What is a complaint? Various other sellers in the e-commerce segment or other retailers, offline retailers, always complain to the government that these particular companies or e-commerce companies prefer some of the traders and push their products during a flash sale, and they reduce the prices to such a level that other sellers in the market will not be able to compete with that. So it will hurt their revenues. At the cost of their revenues, the e-commerce companies are conducting a flash sale. So Government of India has brought in certain regulations or proposed certain regulations with respect to flash sales. What are those? We'll have a discussion later. Next, exclusive launches. What do you mean by exclusive launches? Have a look at this particular nugget of information. In the year 2018, Amazon, this particular e-commerce company, has basically exclusively launched 45 mobile phones in its website or portal or app. It has launched 45 mobiles exclusively, which essentially means these particular mobile phones were sold exclusively on this particular app itself. If you wanted to purchase this particular mobile phone outside, it was not available. And what about another company, Flipkart? As per investigation, in case of Flipkart, during the same year, 2018, it launched 67 mobile phones exclusively in its app, which essentially means these particular e-tailers are entering into agreements with these particular companies, and they are ensuring that these particular products are exclusively present on this particular platform only. Don't you think that violates the right of the consumer to purchase these particular mobile phones outside? So the choice for the consumers is very limited. So that has been the concern with respect to executive or exclusive launches. And the last but the most important one is the concept of the deep discounting as well as predatory pricing. Generally, when they use the term deep discounting, it essentially means on the sale price of the product, around 50% to around 80% discount is provided by the company. Is it okay? You want to purchase a product, let's say through Amazon or through Flipkart. Let's imagine the price is actually 1000 rupees. But when you are ordering this particular product, the company will sell it to you at a discounted price of let's say 50% or let's say at 70%, 75%, why not even 90%? And does happen in case of e-commerce segment. This particular process of giving a huge amount of a discount is called as a deep discount. Now some of you will start thinking, sir, if a product cost is worth 1000 and the company is providing it at let's say 90% discount, does it not incur a loss? Definitely yes, it incurs a loss. But please understand, they are following a basic pricing methodology which is called as a predatory pricing methodology. Under this, what they generally do is they will slash the prices to such a low level that no other seller in the market can match it. And when the customers look at this, obviously they will end up purchasing these particular products from these particular entities or e-commerce companies. But the idea is for a short duration, please remember this, for a short duration, yes, they are incurring losses. But if you have seen the cash or the revenues that are there with these particular companies, these are the companies which are referred with deep pockets. Is it okay? Remember the term. They generally say that these are the companies with the deep pockets, which means what? They have got lot of money. They have huge amount of money. And in shorter duration, by going for a huge amount of a discount, yes, they are incurring losses. But in the process, what they are doing, they are basically pushing out all the other sellers, MSME enterprises, offline retailers out of the business. And when they are out of the business, it has been seen that these particular sellers will start slowly and steadily increasing the prices. So essentially what they have done, they have pushed away the customers of other sellers and they have pushed other sellers out of the business. And when there is very few sellers in the market, if they start increasing the prices like this, consumer doesn't have any other option but to purchase from this particular seller only. So this is again one more very important concern which has been raised by a lot of offline sellers. MSME entities with respect to the pricing practice of these particular e-commerce companies or e-tailers. Now, to address many of these particular issues, the government of India very recently has come out with the draft rules, right, or the amendment rules for the consumer protection e-commerce rules 2020. Now, let's not enter into the nitty-gritties of all of these particular draft rules. You don't have to mug up the technical statements of this. If you understand what is this particular rule mean, more than sufficient. Now, let's try and understand some of these particular very important proposals. One, is Government of India going to ban the flash sales? And that has been the headline in many of these particular newspapers. But please understand, originally 3-4 days ago when Government of India came out with a notification, it initially said they are going to ban the flash sales. But later Government of India clarified that no, they are not going to ban the traditional flash sales. They are only going to ban back-to-back flash sales. What do you mean by back-to-back? Again, there is no clarification which has been provided by the government. Basically what they are saying is, will not ban the traditional flash sales, but there are certain sales which are conducted back to back by some of the sellers on these particular e-commerce platforms. So, we will target those particular back to back flash sales. What is the argument here? Argument is, whenever there is a flash sale, especially back to back like this, here is assume a seller here, let's say seller X, who is selling a particular product through one of the platforms. But the Government of India argues that this particular seller X may not have any inventory. He may not have any goods lying with him. What he will do is, he will simply keep on announcing flash sales back to back of his products, and he will keep on purchasing these particular products back to back from another seller Y. And what is the advantage here? Government says, what if this particular seller Y is owned by this particular e-commerce entity? Is it okay? Imagine Amazon, again I am saying imagine, I am not saying Amazon is doing this. In fact, it has been proven that it is exactly what it does. Amazon is owning one more entity, minor ownership or major ownership, don't worry about it. It owns one more entity, and this particular entity keeps on producing goods. It is not listed on the website, but this particular entity will sell the goods back to one more entity which is actually listed on the Amazon and keeps on announcing the flash sales. So, there is this particular false hope of a demand which is created in the market through the flash sale. And generally experts argue that or criticize that whenever the flash sales are conducted, the quantity which is supplied through the flash sale is very artificially very low. And when there is a term flash sale against a particular product, most of the times what the consumer does is, whether he needs it immediately or in the future, he doesn't think about it. Again, most of the times, most of us, including me. What we do is, when we look at this particular term flash sale against a particular product, we tend to keep on ordering this particular product with the intent of enjoying this particular discount. So, very few or artificially lower commodity is sold. There is a false sense of a demand created for this particular product, and there is a concern that this particular seller who doesn't own the inventory, doesn't have the inventory, just to keep on selling this, will keep on announcing back to back flash sales. So, Government of India says, we will control these kinds of flash sales, not the traditional or the conventional flash sales. But there have been various questions which have been raised by various experts with respect to this particular draft rule. For example, what if I am a person, right, who is owning a particular company, manufacturing a particular product? What if I want to sell off all the stock that is lying around in my warehouse? Obviously, to clear all the stock, I may opt for back-to-back flash sales. In addition to this, Government of India says this particular flash sale is applicable for a specific time period. Now, how will you define this particular time period? So, various concerns have been raised with respect to this particular terminology of a flash sale, because please understand, one criticism generally levied against all of these particular rules by various experts is that these particular guidelines are not specific in nature, these are general in nature. So, when these particular guidelines do not have any legal backing, are not specific, it creates a lot of confusion. And when it creates a lot of confusion, the government officials would want to enforce these particular guidelines in one way, but these guidelines could be understood in a completely different way by the sellers or the e-tailers. And that will basically lead to conflict between both of them. Number of cases will keep on increasing, or litigation will keep on increasing. So this is one rule which has been proposed. Second, the concept of fallback liability. What do you mean by fallback liability? Have a look at this. Imagine here is a e-commerce company. I will order a particular product from this particular e-commerce company. The seller is someone else, and the product is supplied to me. I have made the payment already, but the product which is supplied to me is not exactly the product that I had ordered, or during the process of transportation or logistics, the product has been damaged, or the product which is supplied to me is in inferior quality. So in majority of these particular cases, I want to return the product or I want to raise a complaint. Generally what happens is, this particular e-tailer will ask the customer who has purchased through this particular platform to directly contact the seller. Is it okay? To directly contact the seller. And I do not want to do that. I want to directly go to this particular e-tailer and raise a complaint against this. So basically, government has introduced the concept of a fallback liability. Under the fallback liability, if a consumer purchases any product from this particular marketplace, and if the product is damaged, whatever it is, and the money has to be given back or the complaint has to be raised, the liability of addressing all of this will fall on the e-commerce company itself. Is it okay? The e-commerce company will have to take the responsibility of this. That is a fallback liability. Third one, customer data. Already we have discussed the issue with respect to privacy as well as the safety of the customer data. As per the new draft rules, whenever I provide any kind of data to this particular e-tailer, he has to take my consent if he wants to share this data with someone else. Is it okay? Generally what happens is, these particular e-tailers, whenever they register some of these particular customers, there are pre-checked click boxes. Is it okay? There are pre-checked click boxes. In essence, one of the click boxes, before you basically accept all the terms and conditions, one of the check boxes would have already been pre-clicked, and this particular checkbox will say, in case your data has to be shared to someone else, the company will have the right to share it. Generally this particular click box is already pre-clicked. So now government says, when you collect the customer data and you want to share it with someone else, please take the explicit consent of the customer. You don't have to have this particular box pre-clicked. Take the explicit consent. Generally it essentially means the customer knows that the company is going to share his data to someone else. Okay, that is another rule. Next one, mis-selling. Earlier we have seen the term cross-selling. Now let's try and understand the term mis-selling. Imagine you want to purchase a product from the market through the marketplace. You will purchase, you will order it, and you want to consume the product, let's say after 1 month. But what if when the product is delivered, you will look at the details of the product and the expiry date of the product is after 1 week itself. Now you are forced to consume the product within the next 1 week. But as a consumer or as a customer, when you wanted to order the product, you wanted to have the information related to what is the exact due date of the product, before which date I am supposed to use this particular product. That kind of information is supposed to be provided to the consumer, and most of the times this is not provided by these particular websites or the apps as such. In addition to this, what if most of the times what we do is, before ordering a product, we will go to reviews. I am pretty sure all of you have done, even I have done this. We will check out the reviews and we will see how many people have clicked on 4 stars, 5 stars, 1 stars, and 1 stars, what is the reason? And based on our analysis, at least as a rational buyer, we will decide whether to purchase the product or not. What if these particular reviews are fake? What if the company which is selling the product itself has used various customers or itself has posted these particular comments? How will you find out? That has been one concern which has been raised. So now as per the draft rule, the government says mis-selling will be prohibited. For example, if you want to purchase let's say a product in the website or in the app, clearly the seller has to mention what is the expiry date, before which date you are supposed to use the product. So we are trying to give more powers to the consumers, give more information to the consumers so that they can make an informed decision. Next one, promotion of domestic goods. Various experts are saying this is a Make in India push which is being provided by the government of India. Now what has been proposed in the draft rules? For example, there is an importer of a good. This particular importer of a good has listed this particular good on the platform. Now earlier what used to happen, based on the earlier rules, this particular importer, when he will list this particular product, he has to provide the details of the importer. He has to provide who has imported this information. But now Government of India says, not just the details of the importer, you will also have to provide the details of country of origin. What do you mean by country of origin? Where this particular product has actually originated. Where is the manufacturing of this particular product taking place? You will have to mention that. And not just this, you will also have to provide information if there is any substitute for this particular imported good which is being sold by the domestic seller in the same segment. For example, you want to purchase product X. This is an imported product. Now apart from the imported product X, there is another seller in the domestic market itself who is selling the similar product. So now Government of India says, when you are going to put this particular products and I am searching for this particular products, you will also have to give this information that there is a domestic seller who is selling this particular similar product. So this is expected to provide an impetus for Make in India, or to be more precise, domestic manufactured goods. That is one more very important point here. Now with respect to country of origin, please remember this. The objective is multiple fold here. One, if I am very sensitive and say that I want to buy the products which are manufactured only in this particular country, this will help me in making an informed decision. Second, in various points of time, Government of India would have entered into agreements with other countries, free trade agreements, so on and so forth. In terms of imposing customs or tariffs, it is very helpful if the government knows which is the country of origin. So these are the multiple fold advantages of this particular guideline, promotion of domestic goods. Next one, related parties and associated enterprises. In essence, what do you mean by related party or associated enterprises? Wherein either directly or indirectly, ultimately 10% ownership is there with the e-commerce entity. Is it okay? 10% ownership is there with the e-commerce entity. This is called as a related party and associate or associated enterprises as per the recent draft rule. Now what is the guideline here? It simply says these particular sellers which are related parties and associate enterprises should not be listed in the same platform. They should not be listed in the same platform, essentially to provide a level playing field, because if these particular related parties are listed on the same platform, obviously this particular e-commerce entity will push the products of these related parties, and other sellers on the platform will suffer because of that. So this is one more parameter or draft rule which has been proposed. Usage of a brand name or marketplace. Let me start with an example here. If you have ordered any product through Amazon app, there is something called as Amazon Basics. And whenever this particular brand name Amazon Basics is being pitched to you, you generally have a more tendency because you relate this particular product with the brand name itself. And since you are ordering on Amazon and you are purchasing a product from Amazon Basics, you have a higher security in terms of feeling safer in terms of purchasing the product. So what now Government of India says is, these particular products which will have the same brand name or a similar brand name like this should not be allowed to be listed on these particular websites. And the impact of this is the private labels. Remember this particular term. Private labels will be affected. What do you mean private labels? Generally these particular e-commerce entities will produce some of the goods and tend to give the name of the same brand and try to sell them on their website or through the portal. And again, anything which is produced and sold by the seller himself, it is referred as a private label. So private labels of these particular e-commerce entities is expected to be affected because of this particular guideline. Next, cancellation charges. What is the idea for cancellation charge here? Imagine you've ordered a product on Amazon, and after ordering, you have made the payment. Suddenly you realize you don't need the product, and for whatever reason you cancel the product, and the company will impose certain cancellation charges on you. Now Government of India says, yes, you want to impose cancellation charges, impose it, but one condition. What is the condition? Imagine you've ordered another product, the order has been accepted, you have made the payment, now the company cancels the order for whatever reason, right? For whatever reason, the company, right, let's say Amazon cancels the order. The government says, when you unilaterally cancel the order, same cancellation charges will be imposed on you also. To be more clear, imagine you have ordered, you have paid 600 rupees, you have cancelled, the company charges 100 rupees. Now you have ordered one more product. Now the seller cancels the order, the company will have to pay you 100 rupee cancellation charge. Right? If it is imposed on the cancellation by the seller also, only then he can impose cancellation charge if the order is cancelled by the customer. Okay, this is one more draft rule which has been proposed. Registration with the DPIIT, Department of Promotion of Industry and Internal Trade. Please remember this, as per the earlier guidelines, it was not compulsory for these particular entities to be registered under DPIIT. And to be more precise, it is actually the DPIIT which is the main regulator of e-commerce, not the Consumer Affairs Ministry. Remember this, these rules have been proposed by the Consumer Affairs, but it is not the main regulator, it is the DPIIT which is the main regulator. So until recently and even now, because these are just draft rules, it is not compulsory for the e-commerce companies to be registered with the DPIIT. Now Government of India says it is compulsory. You will have to be registered. What is the logic here? The logic is, when you are registered with the DPIIT, a certain registration number will be provided to you. You will have to display this particular registration number, and whatever invoice you have generated, in essence, whenever you sell the product, you will generate an invoice, and whatever invoice you generate, bills you generate, you will have to print this particular registration number. The advantage of this particular registration process is, one, Government of India will have a database of all of these particular companies, and second, whenever a customer wants to transact with these particular e-commerce companies, he will find it very easy to find out which is a genuine company and which is not. Okay, this is the objective of asking these particular companies to be registered. Next one, Chief Compliance Officer, Nodal Contact Person and Grievance Redressal. This particular rule has been picked up by the government from the IT Act or recent IT rules. Now please understand this, the Chief Compliance Officer has to be appointed by this particular e-commerce entity. What is the idea here? Whatever rule has been issued by the government, the compliance officer has to ensure that these particular entities are abiding by these particular rules or the guidelines. Second, nodal contact person, he is an intermediary between the government or the department concerned as well as the company. And the third, grievance redressal officer. The company has to set up a grievance redressal mechanism and appoint an officer. And not just this, who is the officer? The details of the person has to be published, put on the website or app. And the mechanism through which grievance redressal is provided, that also has to be published. Now some of you will have a doubt as to what do you mean by grievance redressal. Please understand this. If I have a complaint with respect to this particular e-commerce entity, I will raise a complaint and this particular complaint will be resolved or complaint will be addressed. The whole process is called as a grievance redressal. As of now, these particular companies do not have a grievance redressal mechanism. Just like in case of banking sector, there is a concept of a banking ombudsman scheme which has been proposed and implemented by RBI. In the same way, it says the e-commerce entities will also have this particular process of a grievance redressal mechanism, and all the details will have to be published. In addition to this, the draft rule also says whenever the customer raises a complaint within 48 hours, the receipt of the complaint has to be conveyed to the customer, and within next 30 days this particular complaint has to be addressed or resolved. So these are the set of the guidelines or the draft rules which has been proposed by the government very recently. Now what are the benefits? What we are trying to achieve out of these particular draft rules? One, we want to protect the interest of the customer. This is very clear. In many of these particular guidelines you can see that, or the rules you can see that, Government of India is trying to protect the interest of the customer. As such, under the Consumer Protection Act CPA 2019, there are provisions to protect the consumer interest as such. Okay. Now, in addition to this, especially in case of e-commerce, these draft rules have been made in order to protect the interest of the customer in terms of taking care of the safety of the data, in terms of prohibiting the flash sale just to spike the demand in the market, so on and so forth. They also want to regulate this particular sector. In the introduction itself, we have discussed this. This particular e-commerce sector is expanding in an exponential rate, and the value of this particular e-commerce sector is actually kept on increasing over a period of time. In case of India, as already mentioned, it values more than $80 billion, and out of the total retail segment, as of now, the e-commerce accounts for around 5%. And during the pandemic period itself, it had shot up to more than 10% of the total retail segment. So this particular sector or industry is expanding at a very faster pace. So Government of India is trying to regulate this particular sector. Next, it is also trying to provide level playing field. For example, it is also trying to provide a preferential treatment to some of the consumers. It is trying to regulate the flash sales which is affecting all these particular sellers online as well as offline. So it is trying to provide a level playing field for these particular sellers in the market. Regulate the unfair trade practices, definitely yes, and also provide certain benefit to offline retailers. For example, if they ban the flash sales, back-to-back flash sales, obviously it is expected to provide certain benefit to these particular offline retailers who are losing this particular market share at a very faster pace. Now, you have seen what are the benefits we are trying to achieve. So obviously there will be certain concerns related to these particular guidelines or the rules. First one, these particular rules are more in nature for regulating the business. Why this particular point is a concern? Please understand this. As already mentioned, the main or the most important regulator for this particular industry is DPIIT, whereas these particular rules have been proposed by Consumer Ministry. So argument here is, when the Consumer Ministry comes out with these particular guidelines or rules, they should only focus on protecting the interest of the customers. But most of these particular rules have gone beyond this particular guideline, or they have gone beyond protecting the interest of the customers. For example, take the particular point of not allowing the brand names to be used by the sellers, not allowing the connected sellers to be present on the same platform. These are having a larger impact, and if these are implemented in reality, it is going to have an impact on the structure of the e-commerce segment altogether. So these particular rules are not just connected or not covering the interest of the consumers, these are much more or have gone beyond that. Flash sales, yes, Government of India is trying to regulate it, but ultimately the argument is, don't you think the flash sales will benefit the customers? Yes, there are certain flash sales which are just conducted to prompt up or to increase the demand, artificially create a demand in the market. But not all the sellers will do this. Yes, right, not all the sellers will do this. So argument here is whether they are going to sell the product at 50% discount, 70% discount, or let's say 90% discount. Who is going to get the benefit of this? It is me and you people. We are going to get the benefit of this particular product. Yes, all of us will not be able to purchase it, but those who have purchased, don't you think that is a benefit for these particular customers? So it should be the market which will dictate whether the companies are going for a flash sale or not. What if I have got a huge inventory and because of the pandemic I have not been able to dispose of this particular inventory, and the expiry date is fast approaching. So should I wait for the unlock to happen, and by the time unlock happens the expiry date would have crossed, then my products become useless? Or one more option for me is go for a flash sale, provide it on discount, at least I will generate some amount of a revenue during this particular flash sale. So argument here is, how do you control this particular flash sale? How do you differentiate between the one which is done for these particular measures and the one which is to create artificial demand in the market? That is a concern here. Many of the rules are very vague as well as broad. And whenever these particular rules are vague, for example, how do you define a time period in a flash sale? How do you define the specific sellers when you define a flash sale? When you have very vague rules, this will lead to a lot of confusion, and that is exactly what is happening. And if these are implemented in this way itself, that will lead to litigation in the system. Okay, so some of the experts are basically arguing that these rules create more confusion than clarifying these particular issues. May stifle the investments growth in this particular sector. As already mentioned, this is one of the sectors which is expanding at a very exponential rate. And if these particular rules are implemented, then it may simply stifle the investments. It may simply reduce the amount of a participation, or let's say foreign direct investment in this particular sector. Why regulate only the e-commerce? Because argument here is, I'm pretty sure all of us visited the malls, let's say before 2018, because after that, I'm pretty sure all of you have experienced the issue of a pandemic. So you must have seen even the malls conduct sales. Even the retailers, some of them provide a discount on the product. So argument here is, why are you trying to regulate only the e-commerce? Why not conduct certain guidelines, or why not introduce certain guidelines with respect to sales which are given by some of the offline retailers, the sales which are conducted by the malls also? So Government of India's counter argument is, there are different laws, there are different regulations under which all of these are covered. But one definite concern is, the Government of India is trying to regulate only the e-commerce, but this is applicable to all the sellers in the market. So these are some of the concerns which have been raised by various stakeholders with respect to these particular draft rules. Now before I go to the questions related to the discussion that we had, one just a tangential topic, that is the antitrust investigation which has been launched by Competition Commission of India against two giant e-tailers in India. One is the Flipkart as well as the Amazon. Now in October 2019, a group of traders in Delhi basically approached CCI, Competition Commission of India, and they basically argued or complained that these two companies are basically violating some of the guidelines. For example, they argued that, or they complained that these two sellers are practicing preferential treatment, they are practicing predatory pricing, right? As a result of this, or even they argued or complained that they are having exclusive sales of various products or launches. So their argument was, they are violating some of these particular laws or provisions of the Competition Act. So action must be taken against these particular e-commerce companies. So this particular complaint was accepted by Competition Commission of India, and immediately Amazon approached Bangalore High Court and filed a writ petition, basically opposing this particular investigation by Competition Commission of India. This particular Bangalore High Court issued an interim order and stalled this particular investigation. Then Competition Commission of India went to Supreme Court of India. They approached Supreme Court and basically said they want to quash this particular order of High Court. Supreme Court of India again asked or reverted back this particular case to High Court and asked the High Court to look into the matter as soon as possible, within 8 weeks. Now very recently the Bangalore High Court has ruled in favor of Competition Commission of India, and the Competition Commission of India started investigating both of these particular companies, Amazon as well as the Flipkart. This particular investigation is known as an antitrust investigation by Competition Commission of India against these two companies. So this is the gist of the discussion which has been happening in the e-commerce segment. So this is a discussion with respect to one, the draft rules which has been proposed by the government, and the second one is antitrust investigation. Now, based on this discussion, let's have a look at some other questions here. The provisions of a Consumer Protection e-commerce rules 2020 are applicable to 1. Goods or services bought and sold over the electronic network, including digital products. Please remember the statement, this is correct. These particular rules are applicable to selling and buying of goods as well as services and even the digital products. Now, some of you might be thinking, what do you mean by digital product? Let me give a very simple example. You purchase a song online. You have purchased a song online, although this idea of purchasing a song online is very, very novel to Indians, but trust me, there are companies, for example, Apple, which basically sells the products, these particular digital products online. You purchase, let's say, a photograph online. You purchase, let's say, the online learning courses, right? So, obviously, these are called as digital products. So, these particular rules are applicable to sale and purchase of goods, services, including digital products. Yes, this statement is true. Second, all models of e-commerce, including marketplace and inventory models of e-commerce, are also covered under this. Yes, the statement is true. Please remember both of these statements. So, right option is option C, both are true. Second question, consider the following statements. Under the Legal Metrology Act 2011, all the products are already required to carry country of origin labels. This particular term I have not used, but please remember this particular act. Under the Legal Metrology Act, it was passed in 2011, but Government of India amended this particular act in 2018. As per this particular provision, all the importers who are importing these particular products into India, they will have to provide the country of origin labels on these particular products. They will have to print what is the country of origin on these particular imported products. So, this particular provision is already there. So, first statement is true. Second, such labeling requirements are unique to India. Statement is wrong. Remember this. This is not just a unique feature of India. Many countries, for example, even USA has this. So, many countries have this particular idea of a labeling of country of origin. So, right option will be option A, only one is true. One descriptive question, the amendments to Consumer Protection e-commerce rules 2020 will convert the e-tailers from the intermediary to stakeholders with responsibilities. In the light of above statement, discuss the provisions of draft rules. I have used the term draft rules. If these are implemented, that will become Amendment Act. So, you will have to discuss this particular question within 250 words. So, this is the discussion that we have had for the last 1 hour with respect to this particular current affairs issue. So, that is it from my side in this particular current affairs explain session. If you like our initiative, please hit the like button, comment in the section below, and please subscribe to our channel if you have not yet subscribed. Thank you. Have a good day.